Hi everyone, in today's TenderCom video, we will be discussing the Preferential Procurement Policy Framework Act 2000. The main purpose of the Preferential Procurement Policy Framework Act 2000 was to give effect to Section 217(3) of the Constitution by providing a framework for the implementation of the procurement policy contemplated in Section 217(2) of the Constitution, and to provide for matters connected therewith. In terms of Section 217(1) of the Constitution of South Africa, 1996, when an organ of state in the national, provincial, or local sphere of government, or any other institution identified in national legislation, contracts for goods or services, it must do so in accordance with a system which is fair, equitable, transparent, competitive, and cost-effective. Section 217. 2 subsection 1 does not prevent the organs of state or institutions referred to in that subsection from implementing a procurement policy providing for categories of preference in the allocation of contracts, and the protection or advancement of persons or categories of persons disadvantaged by unfair discrimination. Section 217(3). National legislation must prescribe a framework within which the policy referred to in subsection 2 must be implemented. The framework referred to in Section 217(3) of the Constitution is governed by the Preferential Procurement Policy Framework Act 2000. The shortened name of this act is PPPFA 2000. Now let's dive into the framework for implementation of preferential procurement policy, the definitions, exemptions and regulations. Acceptable tender: any tender which in all respects complies with the specifications and conditions of tender as set out in the tender document. Minister means the Minister of Finance. Organ of state means a national or provincial department, as defined in the Public Finance Management Act, 1999, Act No. 1 of 1999. A municipality, as contemplated in the Constitution. A constitutional institution, defined in the Public Finance Management Act, 1999, Act No. 1 of 1999. Parliament, a provincial legislature. Any other institution or category of institutions included in the definition of organ of state in Section 239 of the Constitution and recognised by the Minister by notice in the Government Gazette as an institution or category of institutions to which this Act applies. Preferential procurement policy, a procurement policy contemplated in Section 217(2) of the Constitution. Prescribed means prescribed by regulation, made under Section 5. This Act includes any regulations made under Section 5. An organ of state must determine its preferential procurement policy and implement it within the following framework. Preference point system must be followed for contracts with a RAND value above a prescribed amount. A maximum of 10 points may be allocated for specific goals as contemplated in the specific goals paragraph, provided that the lowest acceptable tender scores 90 points for price. For contracts with a RAND value equal to or below a prescribed amount, a maximum of 20 points may be allocated for specific goods as contemplated in the specific goals paragraph, provided that the lowest acceptable tender scores 80 points for price. Any other acceptable tenders which are higher in price must score fewer points on a pro rata basis, calculated on their tender prices in relation to the lowest acceptable tender in accordance with a prescribed formula. 2. The specific goals may include contracting with persons or categories of persons. Historically, disadvantages by unfair discrimination on the basis of race, gender or disability. Implementing the programmes of the Reconstruction and Development Programmes, as published in Government Gazette No. 16, 1085, dated 23rd of November 1994. Any specific goal for which a point may be awarded must be clearly specified in the invitation to submit a tender. The contract must be awarded to the tenderer who scores the highest points. Any contract awarded on account of false information furnished by the tenderer in order to secure preference in terms of this Act may be cancelled at the sole discretion of the organ of state, without prejudice to any other remedies the organ of state may have. Any goals contemplated in subsection point 3 must be measurable, quantifiable, and monitored for compliance. The Minister may, on request, exempt an organ of state from any or all the provisions of this Act, if it is in the interests of national security, the likely tenderers are international suppliers, or it is in the public interest. The Minister may make regulations regarding any matter that may be necessary or expedient to prescribe in order to achieve the objects of this Act. Draft regulations must be published for public comment in the Government Gazette and every provincial gazette before promulgation. If you need any information, please contact us. We are always ready to assist.